Padilla.
Thank you, Madam Chair, and particularly want to thank you for your leadership on these issues. I think it's vitally important, not just for the innovators and investors and entrepreneurs, but for consumers and workers and the overall health of our economy, that we have an open and innovative and competitive technology sector. So I hope we can continue to work closely together this Congress to build upon the great work that has already been done to better identify market failures and areas of under-enforcement, and to develop more precise legislative remedies to specifically address the issues that we're facing. Now, during the committee's consideration last year of the American Innovation and Choice Online Act, I expressed concerns that provisions of the bill may open the covered platforms to either lawsuits or even threats of lawsuits for decisions they made to enforce their content moderation policies against hate speech, misinformation, and other content that they may want to not host. And several academics, nonprofit groups, and other senators actually voiced similar concerns. And even supporters of the bill approached my office with differing opinions. I was told by some supporters that no such problems existed, while other supporters told me that, yes, the concerns raised were indeed valid. Question for Professor Francis: should we be concerned about the bill's unintended impacts on platform content moderation, and is this an area where the bill can be improved through additional clarity?
I think so, Senator. I'm certainly not an expert on either the practices or the law of content moderation, but as I read this bill from the perspective of an antitrust person thinking about what compliance would look like, I look at two things, and they both give me the concern you've just articulated. So one is Section 3A3 of the bill, which prohibits discrimination with respect to the application or enforcement of terms of service in favor of business users against similarly situated business users. Now, as I read it, that would include content moderation of various kinds that a court ultimately concluded, or even a state attorney general alleged, was discriminatory. And then we look at our affirmative defenses. ICOA provides no defense on the ground that what was restricted was spam, was supplying false or objectionable content, nothing in there that one might plausibly identify with content moderation. So regardless of how one feels about the optimal content moderation law, this very sharply raises the question but doesn't answer it. And to my mind, what that means is litigation, threats of litigation, a lot of uncertainty, and a lot of deterrent effect running in ways we almost certainly don't want.
Yeah. Well, the American Innovation and Choice Online Act, as we discussed and debated in the committee last year, attempts to address several market problems at once. However, I worry that in doing so, it may inadvertently do harm to products and services that consumers actually enjoy. For example, in broadly and presumptively making unlawful the preferencing of a platform's own products, services, or lines of business, is it possible that basic and convenient features of integrated products and services that consumers enjoy and benefit from would be prohibited and subject to unnecessary and perhaps chilling scrutiny? Professor Francis, I'll let you go first here.
I completely share that concern. So things that would constitute self-preferencing cover an array of things that are clearly great for consumers, integrating functions like map results in search, or better integrating your own voice assistant because you found a way to do that, pre-installing apps or features on a device without doing that for the whole world, bundling services together, or even in order to create a more secure and seamless experience, just say, hey, we're going to have a closed system on this part of our platform where we're not going to have third-party participation. All of that stuff is self-preferencing, and then the whole game is whether or not there's harm to competition. Number one, that term is central and undefined. If nothing else, that is a ton of uncertainty. And the prospect of being dragged through investigations, litigations, injunctions, huge penalties, and even having executives' personal compensation taken away, that's going to deter a lot of behavior that we would want to see from platforms that they'd otherwise do.
Okay. Well, I'll just conclude with this, Madam Chair, because I still agree with the stated objective here of our legislative efforts. But I want to continue to work with you and the experts here to make sure that we're getting it right. Thank you, Madam Chair.
Thank you very much. Professor